Some of you may be aware that until relatively recently, the only substantive judgment on noise in the common law world was a judgment in New Zealand. We've had quite a suite of planning of challenges now to wind farms in relation to noise. 3 wind farms, a variety of judgments, 7 in 1 in Cricca and Burnafada wind farm, including 4 substantive judgments at Supreme Court stage. We've, although principally dealing with injunctions, we've had 2 in Burn and Moorhead, one of which is substantive, and that's the leading judgment in this jurisdiction on wind farm noise and damages and so on. And the one I'm focusing on today, Webster and Rollo and Mina Clocksbar wind farm, which is the most recent set of judgments and applying what was set out in the key judgment of Burn and Moorhead. So there's been a lot of interesting teasing out of the principles that are applied. These are very standard nuisance cases, but the facts are very non-standard. So as Fionna kindly said, I was, as a civil engineer, heavily involved in environmental impact assessment and appropriate assessment for wind farms for many years. And this has been the greatest fear the wind farm operators might have had. As long as they don't have peat slippage, as long as the construction goes okay, is the noise going to come and bite them? What are they going to do about it? How can they fix it if it arises? How far does wind farm modelling go in predicting the problems? How far does the planning process protect them? How far does compliance with noise conditions protect them? And now we know a lot more about those answers. So they can now see the problem. We've learned a little bit more about what it is about the noise that causes the problem. There's still a long way to go in terms of the science and assessing what it is specifically causes the problem. So I'm going to briefly touch on Burn and Moorhead and what they did, and then get into Webster and Rollo. I have this clip. I was wondering whether I'd play it or not, but I decided I would. Okay, so it's not the best clip in the world. So, health warning. It begins with standard wind farm noise and ends up with amplitude modulation. Now, you'd have to listen quite carefully because it's short, it moves in quite, you will start to hear a thumpier sound by the end. So the health warning is this. The initial noise sounds worse than most wind farms do, and the amplitude modulation is not as bad as I've heard it. So, but look, it's the only one I could find. So for those who haven't been to wind farms, I don't know if this will work, actually.
I don't know either.
We'll find out. Let me just see if this works. And if not, I'll leave you all disappointed to hear some wind farm amplitude modulation for another day. Okay, doesn't sound like it. In any event, the only thing you really need to know, if you've been to a wind farm, you'll have made up your own mind. If you haven't, it's a relatively gentle sound. A lot of people are quite surprised. Now, some people are noise sensitive. Not everybody will have the same reaction. That has to be said first. But it's very much a broadband noise. So it sounds a little bit, has characteristics similar to the wind itself, to waves breaking. It's not an industrial type noise if there's nothing wrong with your turbine, a swish or a swoosh sound. But if you've heard amplitude modulation, that is definitely a thump. You do not want that near your home. So, which is enough about that. So, Burn and Moorhead set the tone for what a court will do if they find nuisance from wind farms. And as I say, set the tone. Every set of circumstances is different. So there were 6 turbines in Benclody. Halfway through the trial, the defendants admitted liability. So the defendants sought damages to be measured by reference to the notional capital damage to the value of the plaintiff's property, but the plaintiff sought that damages would be by reference to broader principles relating to the assessment of general damages, focusing on the impact of nuisance. So Mr. Justice Quinn followed the Hanrahan principles and confirmed and essentially said you don't get more damages really just because you have a more expensive property. So he awarded €10,000 per year of nuisance to one plaintiff and 15,000 to the other, and that was the basis on which Miss Justice Egan in Webster and Rollo, she took as her starting point and then looked at the differences between them to set out what she would do. Incidentally, I think there must have been, 10 years. In any event, it was a very substantial amount of damages when you added up all the years. That was insignificant compared to the shutting down of 3 of the turbines. Insignificant. So the damages will mean very little to a wind farm operator compared to shutdown of turbines on the whole. I think I can go back into. So they focused on the interference with general ability to experience and enjoy their home, standard nuisance approach. The interference was particularly acute in terms of sleep disturbance and loss of enjoyment of the garden. These are features they see in Webster and Rollo also. One thing that affected the award of damages was that Mr. Byrne was away for a very significant period of time, so he had the lesser figure of 10,000 per year. 12 years of nuisance, so 120 and 180,000 euro. But for 12 years of nuisance, in the context of what it cost the wind farm operator relative to the overall operations, it still wasn't an awful lot, actually. They also wanted damages for claim to capital value due to the noise nuisance history, so haunted house syndrome. That bad thing happened once, So how do they look at the effect of, the turbines are shut down now. There is no more problem. Is there still going to be an effect on property values? As I say, haunted house claim. The court was not persuaded. So stigma damages is what they were looking at. And they said it was too speculative. On the other hand, different arguments were brought to bear in Webster and Rollo, and stigma damages were awarded. But it was different circumstances. Another arm of their argument was reinstatement costs. So, buying or building, an equivalent house farther away. And, they said this was rejected in both cases because it was a new for old, essentially, they would be getting a new house, whereas their current house is 20 years old. So the permanent shutdown of 3 turbines, that's a much more serious consequence than the money. They did award aggravated damages in Byrne, which they refused to do in Webster. So they said, and this is a theme, though, common to probably the 3 wind farms. The general response of the defendants was exceedingly poor. I think sticking your head in the sand probably completely describes the response of the defendants in the 3 cases, including Cricket. So the defendants declined to cooperate with the investigation of the local authority. I should say that Wexford County Council had appointed consultants to investigate wind farm complaints at not just these 2 wind farms, but a further 2 also. And they found amplitude modulation in all 4. Which is very interesting because they're not the first wind farms that have had complaints made where measurements have been made shown to be within planning conditions. Everybody backed off, but there was no suggestion in those other cases in other local authorities that amplitude modulation or any thumping sound arose, and that's critical because the normal operation of a wind farm should not have amplitude modulation. It only crops up in limited cases, and even then limited wind speeds, limited times of the day. It is something very particular, and it is potentially amenable to mitigation by use of software to avoid those wind speeds and times of the day. None of the wind farm operators in any of these three cases engaged with that properly, and it was available for all three and known to be available. So they didn't provide the requested information, and they didn't they didn't examine mitigation. So aggravated damages were merited. What the Judge Quinn said was the only sensible inference that can be drawn is the defendants made a decision not to engage in any substantive or proper way with the claims being made by the plaintiffs, and this aggravated the obvious distress suffered by the plaintiffs and significantly prolonged the duration of the nuisance. So they were awarded an additional 20% on top of their compensatory damages. They were not awarded in Webster, and probably the only thing that distinguished with them was that they properly engaged with the proceedings and brought in a noise expert to engage with the plaintiff's noise expert, which was not done in Byrne, and that's probably the only thing that saved them from aggravated damages. Exemplary damages not awarded in either case. I'm kind of conscious of the number of slides I had, so I might skip on a few of them, but it didn't engage. It said that there was not so conscious and deliberate a violation of the plaintiff's rights as to merit the sanction of an award of exemplary damages, and the same finding was found in Webster. So there was the principal judgment, and again, you could give a whole presentation on any one of these. So they found that there was amplitude modulation and low frequency noise. There were tonal components in Byrne as well that were not found here. So what Justice Egan said was there were multiple attention drawing features such as impulsivity, being sudden changes in sound level, erraticism with no clear periodicity or rhythm, exhibiting spikes and double spikes of amplitude modulation, and variability or intermittency when amplitude modulation disappears and returns again. And she found that those features, which were particularly evident in light of the high amplitude modulation values displayed, meant that the noise lacked any pattern to which the nearby residents could acclimatise, and therefore it impacts coping mechanisms. So in both cases, the court found that the noise is intolerable and represents an objectively unreasonable interference with the plaintiff's immunity and enjoyment of their homes. Now, this was notwithstanding that they were within their noise conditions, but you can't predict amplitude modulation, and you can try and put on penalty conditions to say that if there are any thumps or unusual noises, what that does is you can add on a penalty of, say, bringing down your noise condition by, say, 5 decibels. Will that cure it? I'm not sure anybody's actually looked at that, because you would certainly have to change your wind turbine operation in order to have it operating at a lower level. I'm not convinced that will really work. I think the software approach is probably a stronger approach. Miss Justice Egan, in reading Byrne, suggested that the unsettling and psychologically distressing sense of vibration and pressure emanating from the turbines in Webster was a more prominent feature of the noise than was the case in Byrne. There was complaints of how the house was vibrating with noise, which appeared to reverberate through walls and ceilings. That did not arise in Byrne. So she evaluated the differences between the experiences of the occupants in looking at the award of damages, as opposed to the expert report. So she very much followed Hanrahan principles from that perspective. She said the noise was tolerable in the daytime. So it was just unlike Byrne, where the defendant admitted the noise was 24 hours a day. This is because amplitude modulation due to wind shear is usually, it can be worse at night time. It appears that was the case here. So it was turbine 2, so it was just the one turbine, caused a nuisance to the plaintiff's nighttime hours and quiet waking hours. So it is those hours to which the injunction applies, and at certain wind speeds. So it was not a complete shutdown like Byrne. It was a partial shutdown. So she said that the turbine noise gives rise to serious adverse noise impact exceeding reasonable tolerability by a substantial margin. The enjoyment of the plaintiff's homes as places of rest and relaxation was substantially interfered with by annoying, distracting, unpredictable and intrusive noise, as well as vibration and a sense of pressure. The erratic and unpredictable amplitude modulation, thumping, vibration and low frequency pressure is disturbing, distracting, distressing, both externally and internally, particularly at night, early in the mornings and at sensitive times of the day. And the plaintiffs had no control over their own sound environment. It sounds even distressing reading it, to be honest. They've no ability to simply be quiet in their homes, despite their secluded rural locations, no respite open to the plaintiffs, and the interference caused all 4 plaintiffs to experience serious and frequent sleep disturbance with all that entails. What's interesting, though, is the second 2 plaintiffs, Miss Carty and Mr. Shorten, sold their property, and the new occupant is fine. So, these things are all very particular to both the individual circumstances and to the people involved. People live close to very noisy roads with noise that would drive other people distracted. People refuse to live by noisy roads. Other people don't even notice. So there is a subjective element, and that's what makes these difficult in terms of finding nuisance. What's reasonable? But in this case, they're in these cases, in Byrne and in Webster, there was little doubt that threshold had certainly been met. So there was exhaustion caused by lack of sleep, which interfered with the ability to concentrate, read, and at times to work. They were deprived of the enjoyment of their gardens, as in Byrne, and the level of interference was objectively supported by the plaintiff's expert acoustician, so that they kept records of the times when they found it the noise most irritating, and that aligned with the expert reports evidence of amplitude modulation in particular. They said the behaviour and response of the plaintiffs to the turbine noise was in general that of objectively reasonable and patient people. So that's a very important finding in finding for the plaintiffs. The general response from the defendant was exceedingly poor. There was an injunction was given. I mentioned that. So abatement at sensitive periods being nighttime and quiet waking hours and restrictions on wind speeds. And again, I could have probably presented just this second judgment alone. But this was one of the features, actually, though, that resulted in the finding that there would be stigma damage, because the occupants would be required to engage over a lengthy period of time with the operator in order to ensure that the nuisance was in fact being abated, and that this, and they advanced other arguments with that. They won on that argument in terms of stigma damages, because if they sold their property in the morning, the new owners would have to engage in the same manner. That was not the case in Byrne, because they were just shut down. So the damages. So there was no substantial disagreement between the noise experts on the features relevant to noise being a nuisance, that it was not simply loudness, but that it was also pitch or frequency, as I say, amplitude modulation, different noises from the same source, sound source, changeability, erratic or unpredictable changes, tonal noise, duration, timing, nature of the environment, sensitization and attenuation. I'm going to just skip through the nuisance legal principles, which she went through in great detail. But that the nuisance is so pronounced, prolonged or repeated that a person of normal or average sensibilities would not be expected to put up with it. I'll just run through that. Property devaluation, I have mentioned that. So there are no authorities or none that were brought to the attention of the court in relation to property devaluation or stigma damage. But she simply applied the well-accepted general principles set out in Munnelly. That was where part of the plaintiff's house collapsed as a result of the neighbour's building next door, and they wanted reinstatement costs. And what they said was, and they didn't do that. So they said the reinstatement would enrich the plaintiff excessively and unnecessarily and would mulct the defendant unreasonably. So they look at the relation between the parties of the award and what it would do to each party. And so they didn't award them. And that was a theme, as I say, in both Byrne and Webster. They weren't going for reinstatement costs. So there were 4 issues arising. The general damages, Miss Webster and Mr. Rollo split up. They said as a result of the stress and the psychiatric damage which Mr. Rollo endured. So he had managed to spend €42,000 over a number of years in rent, and he wanted his future accommodation provided for. So there was the property devaluation question as the third question, and then the question as to aggravated or exemplary damages, although I got to that. So under general damages, so Miss Webster was continuing to live in Hill House. Her partner left. It was not disputed that he suffered a major depressive disorder of at least moderate severity with low mood, sleep disturbance and irritability. He therefore suffered recognisable psychiatric injury. He lost his home, his relationship, his plans to have children and a future together as a family. He was particularly hurt. All the plaintiffs were that the defendant failed to engage, and in particular, the defendant was notified of Mr. Rollo's mental illness and furnished with a medical report expressing grave concern for Mr. Rollo's life and requesting that as an interim measure the turbine was switched off at night to allow respite, and they did nothing. Now they decided the issue of the breakup of the relationship attracted some attention. They had decided to separate in the summer of 2020, which predated his mental illness, which was precipitated by the noise, and was accepted that it was precipitated by the noise. So the Carty Shortens built Nettlefield in 2017. They lived elsewhere. This was a weekend home. It was with the intention of retirement at some stage. So this attracted lesser damages. They said. They claimed variously that they sold as a result of the difficulties, but it emerged that they in fact had earlier decided to sell it for family reasons before the wind farm was constructed. So they were claiming that it cost them €500,000 to buy the site and develop it and furnish it, and they sold it, including contents, for $305,000. So they sought the loss and devaluation. So it hadn't been pleaded on devaluation. It had only been pleaded on differential market values of with nuisance or without nuisance. So that was given some attention to. Those were the issues in the general damages. In terms of Mr. Rollo, so he said that even if it's abated, he can't go back to the house now, which he half owns, because the relationship is broken down. He sought, as I say, the reinstatement value, and so he said that to build that now would cost €1 million. It's clearly a fine property. It was not pleaded in the special damages, but the question was, should it be part of the overall circumstances in relation to damages? So taking those two together, Miss Justice Egan called the judgment in Byrne a landmark judgment, which it is. So she awarded the same amount as was awarded in Byrne to Mr. Byrne, to Miss Webster, €10,000 a year from the period of February 17 up until the date of abatement. So that was $87,500 at the point of the court judgment, and to continue until there was satisfaction that abatement had taken effect. Mr. Rollo got a heightened award of $18,500 because of his psychiatric suffering, but that wasn't a head of damages on its own. The Carty Shortens got $7,500 each, and they awarded damages for reduction in capital value by virtue of the noise of $55,000 in Nettlefield and $30,000 for Hill House, and those were nothing like the sums they were seeking. So They excluded from the general damages the psychiatric injury, the breakdown of the relationship, and the time period after Mr. Rollo left Hill House, and having huge sympathy. But they said the breakup of the relationship, there was an issue in terms of causation. They could not be sure that it was the wind farm that caused it. And secondly, and including the psychiatric injury, they said these were not reasonably foreseeable. So damages were not going to be awarded for those. And neither was she going to award damages for the past or future accommodation, because she said that arose out of the breakup. So she wasn't satisfied as to causation there. So I've gone through the stigma damages. There's detail on the slides on the property devaluation, which if anybody's interested, they can have a look. There was some criticism of the expert evidence, which because the same experts were involved, many of them as had been involved in Byrne. And in Byrne, the expert valuer, one of the expert valuers, had changed his position dramatically in his evidence to the court relative to his report. And the reason given for that was that he had read all of the witness statements and transcripts from earlier on. And he changed, in this case, given that the witness statements and transcripts had such an effect on his evidence, he was severely criticised for not doing the same. In this instance, he was barely acquainted with what had been decided in the principal judgment. He had not read it. He had not read the transcripts of the witnesses or the witness statements. So she took much less credence that was given to his report than to the other valuer. So there's a comparison between Byrne and Webster, which I leave for the slides, but essentially it was €10,000 per year for Miss Webster, 18,000 for Mr. Rollo, and 5,000 per year for the that was the offer. They were looking for significantly more, and I gave you the slides. It was 10 and 18. I've mentioned the slides go into more detail on aggravated and exemplary damages, but I think I've dealt with those. And I will mention the approach of the defendant, because this is something that was common to all of them, and probably why they ended up in the courts and others haven't.
And just 1 minute, we have to wrap. Thanks, Fionna.
Okay. The approach of the defendant was unimpressive, prolonging the upset, disturbance and distress. But it wasn't sufficient to attract damages, that he was unneighbourly, essentially, that he made an offer of €4,000 per house, which was derisory, particularly when it required a noise acceptance agreement to be noted in the deeds to bind all future purchasers. So an absence of apology was considered very important. And in particular, there was criticism of the absence of mitigation. So the court, in light of the public benefit of renewable energy, the court decided to permit the parties a period of time to agree mitigation measures, found the defendant's approach to mitigation to be entirely unconstructive. They simply offered to operate it in a quieter mode. This did not solve the problem. He did not look at other approaches. So she was satisfied there was no real attempt. She said that the efforts made in mitigation did not address the characteristics and features of the noise identified by the court as giving rise to nuisance. So he operated a slightly lower mode, but it wasn't addressing amplitude modulation in particular. They found that operating in that mode is incapable of addressing the characteristics of concern. She was prepared to offer a more nuanced injunction. And the reason she didn't was because the defendant didn't engage, as had been in the case in Byrne. If they had engaged and said, look, we think we can solve the problem by being more restrictive in our operation, they wouldn't have been shut down completely. But she said it nonetheless didn't amount to oppressive, arrogant or outrageous behaviour sufficient to award aggravated damages, and the matter was not so deliberate and conscious as to violate the plaintiff's rights, so exemplary damages were not awarded. So the court made overall comments, just 2 slides. That the case had many of the features exhibited by Byrne. Engagement by the defendant is poor, and didn't engage properly with the experts' reports for the plaintiff. Despite being given every opportunity to mitigate, they didn't call on the turbine manufacturer or other engineer, which seems just incredibly difficult to understand. As in Byrne, didn't carry out any straightforward assessments of whether the plaintiff's claim have substantive merits, just dived straight into a deny everything defence. And Miss Justice Egan was deeply unhappy with this. She said that such behaviour represented a threat to the goal of developing wind farms in energy, because obviously they were making very enthusiastic claims that, look, we need this for climate change. But she said they had actually engaged in the proceedings and brought in an expert, and although she was deeply impressed by the behaviour and because of the order she was making in relation to not completely shut down Turbine 2 at night, that she would not, in this case, award aggravated damage. So it's just interesting to compare that with Byrne to see where the court will and won't, and because different arguments were made, even though they might have been made in Byrne, but weren't. So
thank you, Fiona, and sorry